Good morning. Good morning. Welcome to Law School Palooza 2014. Last day. So, we're going to start now. We're going to do a review. We'll take a break or some breaks, and we'll go to however long it takes. We'll look to be done by about 3 o'clock. Okay, here is the sign-in sheet. Now, a couple reminders. Remember all the problem sets that are available online. St. Thomas Law first-year exams are, by requirement, as you know, cumulative. And Civ Pro, as a topic, is by necessity integrated and overlapping. So a lot of the stuff we'll be talking about today will involve both the first term and the second term, because many subjects, such as Rule 12 and Section 1367, by necessity tie in things that we learned earlier in the year. The problem sets are something you can go back to look at to help you in your studies. Equally so, don't forget the many handouts, such as the discovery questions, such as the handouts we've done for issue preclusion, Rule 19 joiner, and all of that stuff. You can find those on the course website. Now, in the exam will be a 3.5-hour exam for which you'll get 4 hours to do. So in other words, just like my fall exam, there will be a half an hour of slack time. I recommend that you very carefully structure your time to make sure you can finish the exam. Make sure you talk about relevant subjects and not negative issue spot. I will be giving you a handout that has the complete text of the FRCP, along with relevant statutes and relevant provisions of the U.S. Constitution. So you don't need to memorize any of those rules or statutes. Rather, your goal as always should be to understand them, to be able to spot issues that require analysis of them, and then use those rules and statutes along with case law to do your legal analysis. All right. What I thought we would do today is start off with things from the spring. And as necessary, we're going to harken back to matters from the fall. And then we'll see how much time all of that takes. And then with time remaining, we may do some review of the fall as well. But I suspect that what you'll see is we'll be talking about a lot of fall subjects in our spring review. And also, one last thing that comes to mind about the final exam. You know, yes, everything from the whole year is something that can be on the exam. PJ, of course, will be part of the exam, but you will recall, as I'm sure you very well recall, that there was a really big PJ issue spotter on the fall exam. Accordingly, there will not be a big PJ issue spotter on the spring exam. Certainly, we have plenty of other things that are worthy of testing on. So that's one thing you won't find. PJ will still be part of the exam in some form, right? Because it's a major part of what we study. But don't look for one of those hour-long issue spotters. Coffee. All right. Let's start off with pleading. All right. Let's start off with pleading and Rule 8. And particularly the line of cases that led up to Iqbal and Twombly, right? Now, Rule 8, particularly Rule 8a, details what needs to be put in a pleading in order to state a claim, right? A short and plain statement of the court's jurisdiction, a short and plain statement of the claim showing entitlement to relief, and a prayer for relief. Now, in the past when I've tested on a 12b6 motion, students often analyze all 3 parts of Rule 8a. But if you have a 12b6 motion, what that's generally going to be testing is the sufficiency of the pleading under Rule 8a2. In other words, whether or not you have a short and plain statement of the claim showing important word, showing entitlement to relief. Let's think about that for a minute. Now, a lot of you have done the ALI practice question about Justin Bieber and the cruise line, right? And very few of you hit the fair notice issue. So let's talk about Conley versus Iqbal for a moment. Conley had two components. One was the idea of no set of facts, and the other one was fair notice. No set of facts meant that a complaint should not be dismissed unless there's no set of facts out there consistent with the pleaded facts that would entitle the pleading party to relief. Okay? So what that meant is the pleading party was entitled to all reasonable inferences that weren't contradictory to what was already stated in the complaint. And if you could take the facts of the complaint along with those reasonable inferences, and that would state a claim, then you shouldn't grant a motion to dismiss under Rule 12b-6. Well, as you can imagine, that might encourage pretty conclusory pleading. However, Conley was never that simple. There was also the requirement of fair notice. Okay? What fair notice meant is the complaint should contain sufficient information to give the defending party the grounds for the claim so the defendant can start preparing his, her, or its defense. Okay? Now, harkening back to Justin Bieber, that complaint had what? There was a count for negligent failure to maintain the steps, right? And negligent overserving of alcohol that in the alternative or cumulatively caused his injury. All right. Well, this complaint gave the cruise line fair notice of what it's being sued for. It had the who, what, where, when. Okay. The cruise line would be able to figure out what it's being sued for, what the legal theories were, who the parties were, and it could start to mount its defense. It had fair notice. Now, fair notice is still good law after Iqbal. Okay, and a lot of you missed the fair notice issue in your practice essay. No set of facts, however, is not the law anymore. All right, that was thrown out by the Twombly Court. What that means is when you're analyzing a typical 12b-6 motion, one that involves, say, like negligence or breach of contract, not something like fraud, where you have the higher standard of pleading under Rule 9b, but something like the Bieber hypo. All right, you have to talk about fair notice as well as Iqbal. What that means is you got a two-part analysis, and the second part has two parts, right? So the first part is going to be fair notice, and the second part is the Twiqbal, right? Twombly plus Iqbal. The Twiqbal plausibility analysis. Now, the plausibility analysis itself has two components. The first one is separate, say it.
Legal from the fact.
Yeah, separate the facts from the legal conclusions. All right? Now, a lot of you in your practice essays are just saying, well, this allegation's a fact, that allegation's a fact, the other one's a fact, but this other one, that's a legal conclusion. Wow, sounds like you're making legal conclusions regarding what's a fact and what's a legal conclusion, right?
Yeah.
But remember, the cases tell us that it gives us some guidance, not a lot, something that's like a threadbare recitation of the elements. The defendant breaches duty of care, all right? That's a legal conclusion. Defendant was negligent. That's a conclusion. Other things like defendant was an owner, that's a little harder, right? Maybe you want to give analysis and counter-analysis. But if you're going to tell me what's a fact and what's a legal conclusion, tell me why as well. Don't yourself commit the sin of giving legal conclusions about legal conclusions, all right? Separate them out. Then what you got, like, it's a filtering mechanism, right? What are the facts? And then you can only consider the facts. You treat them as being true, and you move into the second step. You ask whether or not the well-pleaded facts state a plausible claim for relief, right? And here the court tells us a couple things. It tells us that we need plausibility is more than a possibility, but doesn't have to be as high as probability, right? So Put differently, possibility is down here, and probability is up here. Then plausibility is baby bear, and that's where you want to be, even though it's a murky line between possibility and plausibility. Okay? The complaint has to show, remember Rule 8A2, show entitlement to relief. And that's what the court's getting at in Iqbal and Twombly. Show entitlement to relief by nudging us from the merely possible to the plausible. So getting back to the Bieber hypo, you'll recall, or at least many of you concluded, that the only well-pleaded facts in count 1 were that the defendant owned a cruise line, Bieber was a passenger, Bieber fell on the steps and hurt himself. Okay? And therefore, the defendant is liable. That last statement being a legal conclusion. Okay? Well, you think about it. You got to look at your plausibility analysis in the context of the governing law, right? Here, the governing law was negligence, right? For those of you that look, oh, by the way, here's another thing that you may find helpful. Don't forget that at nathanson.org, all right, nathenson.org, click on Civil Procedure, and you'll find a link to the past 3 years' worth of essay exams. Last year's essay exam had a Iqbal hypo, and the governing law wasn't negligence, it was conversion. And I provided a statement of what the law of conversion was, right? So you've got to use the governing law and then look at the relevant facts and ask whether they state a claim. Do you have facts that, if true, would add up to a claim that shows entitlement for relief? Well, let's think about negligence in Bieber. Here we have the facts. Bieber fell on defendant's steps. Boo-hoo, defendant's liable. Let's think about it. Duty. Duty is a question of law, right? The court's going to tell us that. What about breach? Causation. You know, and I'm going to just collapse for present purposes cause and fact and proximate cause, right? And damages. Well, we have allegation for damages. He hurt himself. He had medical damages and all of that. All right, medical bills. But what about breach? What about causation, right? You know, if I fall off of this lectern here, that doesn't mean that somebody besides me was negligent. There could be lots of reasons why I fall down that have nothing to do with someone's negligence. And equally so with the Bieber hypo, right? What we can do is have inferences. Bieber fell, defendant steps. What are the inferences you can draw from that? One is that the defendant, cruise line, was negligent in maintaining or keeping clean or clear the stairs, right? The other one is the defendant wasn't negligent, or to speak more accurately, that the defendant didn't breach, right? Now here what you've got to do is use what Iqbal calls your judicial experience and common sense. I might call it your life experience and common sense. Or I might even just call it your developing BS detectors, right? What's more likely? What's more likely? If the only facts that we know, you know, we're taking the allegations to be true facts for purposes of the motion, the only facts we know is that Bieber fell on the defendant's steps. Is that enough to fill in the gaps of breach and causation? Well, let's think about that for a second. You all say no, but remember, what we do is we make inferences from the missing facts, right? Is it possible that Bieber fell because the defendant breached some duty? Yes. Is it also possible that the defendant fell, is it also possible that the plaintiff fell for a reason that had nothing to do with the defendant breach? Yes. Let's think about it. Let's use our life common sense. Maybe the plaintiff just wasn't watching where he was walking, right? Maybe somebody spilled some ice cream there 30 seconds before, and the defendant hadn't had a reasonable time to learn of the spill and to clean it up, right? There's lots of reasons why people get hurt that don't have to do with breach. Now what you got to do is compare. Which one's more likely? Breach by defendant or not a breach by the defendant? Now I'll leave it to you to discuss. I think most of you concluded the thing that was more likely was that there was no breach. Okay? Well, this is how Iqbal works. In Iqbal, the court said, well, you know, of the competing inferences, the one that's more likely is of no discrimination, right? And equally so in Twombly, the court said, the inference that is more likely is of no conspiracy, okay? No agreement to restrain trade between the telephone companies, all right? So what you got to do is, Iqbal situations come up when you got a hole in the facts, in the context of the relevant law, and then you draw the inferences, and then ask which one's more likely. And if the more likely inference is the one that leads to liability, then the complaint states a plausible claim. All right? Now, under Conley, count one very arguably would have been okay. Because didn't you just say a few minutes ago that it was possible that the cruise ship in our hypo had breached, right? Y'all said that, right? It's possible. So would there be a set of facts consistent with the allegations of the complaint that, if true, would state a claim? The answer definitely is yes. Okay? So under Conley, count one should not be dismissed. But under Iqbal, there's a strong argument that it ought to be. Now you remember there was another account in that fact pattern which said something like this: a defendant noticed that the plaintiff was intoxicated, but served him more alcohol anyway, and the defendant negligently overserved alcohol to the plaintiff, and then that's the reason why the plaintiff fell down on the stairs and hurt himself. Okay. Now, some of you in your hypos struck out entire sentences when the word negligently was in there. But that's not how Iqbal works. Okay? You can go clause by clause or even word by word. So if the allegation is defendant negligently overserved alcohol to the plaintiff, that doesn't mean the whole sentence is a legal conclusion. Rather, what you can do is call out the word negligently. That's a legal conclusion. And then be left with the following fact: defendant overserved alcohol to plaintiff. And if you end up with the facts being plaintiff was drunk, defendant saw the plaintiff was drunk, defendant overserved him more alcohol anyway, and then plaintiff fell down, all right? Well, look at it. Do we have facts for each and every element? Did defendant breach a duty? I would think yes, right? It's a cruise line. You're the tort experts, not me, but I'm thinking something like an innkeeper kind of duty, a heightened duty, right? Because it's a cruise ship. Okay, breach. And did that breach cause him to fall? Either of the facts right there saying it caused it, or the inference that he fell because he was drunk seems to be much more likely than the fact that he fell for some other reason. You see how much easier it is to find a plausible claim here? So this is the kind of thinking that you want to do in an Iqbal fact pattern. We accept the facts, the well-pleaded facts is true, and then ask about plausibility using a judicial experience and common sense, or life experience and common sense, or just your flat old BS detectors. And I guess one last note on Iqbal is, we do accept facts as being true, but in the dissent, Justice Breyer points out that we don't accept, fantastic allegations about, time travel and little green men, right? So for that, you also might want to go back and look at the Brian, Stewie, and Meg hypos. Hypo number 4 involved Stewie going back in a time machine, wasn't it? Yeah, to attack Meg with Ryan's blue Prius. All right, now let's move on. What other fun stuff can we discuss? There are, of course, other important rules regarding pleading. Don't forget about Rule 9b, right? Rule 9b, that allegations regarding intent and state of mind can be alleged generally. However, the circumstances of fraud must be stated with particularity. The same thing is true for allegations of mistake. I would assume mistake is something that you've discussed in your contracts course with Professor Sullivan?
Yes.
Mistake?
Yes.
Yes? Okay, good. So fraud or mistake, circumstances plead with particularity. And of course, pleadings themselves, we now know really well what the pleadings are, right? Rule 7 makes the distinction between pleadings and motions. Pleadings under 7a fall into 3 categories. We have complaints, we have answers, and we have the reply. Complaint could be either a complaint, which starts litigation, or a third-party complaint. In other words, something for completer under Rule 14. You could have an answer to the complaint. You can have an answer to a third-party claim. Let's see, what else? You could have answer to a counterclaim designated as such, and you have a reply. How many is that? 6 or 7? That's 7? Did I give all 7? Okay, and the reply. And 6 of them, in other words, the complaints and the answers are required under the rules, right? But a reply is only permitted when the court orders it. All right, moving on. We'll go one thing back about Conley. So let me use Stewie's time machine there. Go back about 2 minutes. Rule 84 and Form 11, right? Why is Rule 84 and Form 11 important? Well, Rule 84 tells us that the forms in the appendix to the FRCP suffice under these rules. In other words, these are examples of things that are okay. Now, Form 11 is a generalized complaint for negligence. It says something like, at place, on a date, the defendant negligently struck plaintiff with an automobile, and then it caused damages and harm and blah, blah, blah. All right. Well, let's think about it. Let's separate the facts from legal conclusions there, right? What's the legal conclusion in this? On date, at time, defendant negligently struck plaintiff with a motor vehicle.
Negligently?
That's right, Sophie. Negligently. So let's leave the facts. On date, at place, defendant struck plaintiff with an automobile, causing all the damages listed, right? Well, duties determined by the court. Here would be what? Duty of reasonable care, right? All right. Do we have allegations of breach? Well, maybe, maybe not. We'll get back to that. What about the damages? It would appear that we have an allegation that the damages were caused by being struck. The real question is about breach, right? You may think, oh, there's an allegation regarding breach, but is there? Defendant struck plaintiff with a motor vehicle. Every time a defendant strikes a plaintiff with a motor vehicle, does that mean there was negligence on the part of the defendant? No, what might happen? What's that? Well, yeah, an accident. Are accidents always the driver's fault? No. What circumstances might cause the defendant to strike the plaintiff but aren't due to the defendant's breach?
Products liability, bad break.
Maybe a bad break. Maybe it's somebody else's fault. The defendant was driving safely, right? And it was bad brakes, bad tire. What else?
Plaintiff runs a red light.
Plaintiff runs a red light. Or the plaintiff walks out in front of the vehicle, right?
Mm-hmm.
You know, in fact, Form 11 is ambiguous on whether or not it's one car hitting another, right? Or one car hitting a person, okay? We can go back and check that, but I've always thought of it as a person, but you may well be correct, Travis. But regardless, you think about which one's more likely. Defendant strikes plaintiff with a motor vehicle, okay? One allegation is because of a breach, one inference is because of a breach by the defendant, the other one is because of no breach by the defendant, right? Which one in our life experience is more likely? Which one's more likely, you think? Breach or no breach? I think breach. And if for no other reason, if you want just one additional reason, Form 11 is okay because Rule 84 tells us so, right? So that must be enough to show plausibility for the breach. So what's the lesson of Form 11? Well, one lesson is that you really don't have to have detailed factual allegations to satisfy a Twombly, right? Short and plain statement of the claim can indeed suffice today, even under Twombly and Iqbal. More facts doesn't mean plausible. More facts might make it plausible, or I suppose could make it plausibler, right? But Rule 84 and Form 11 are a reminder that you really don't need a huge amount to pass muster under the Iqbal standard. All right, now we move on. All right, the defendant's options. Plaintiff has filed a complaint. the complaint and summons had served on the defendant. Now, under Rule 12A, the defendant has how many days to respond? 21. The defendant has a couple options, right? The defendant could default. Rule 55. The defendant could do a pre-answer motion. Rule 12B or 12E or 12F. Or the defendant could answer, which is going to be Rule 8, various parts of Rule 8, particularly Rule 8B and 8C. All right. Now, under Rule 55, if the defendant chooses to default, and sometimes defendants do choose to default, maybe they think there's absolutely no jurisdiction, and they'll take the default. And then if the plaintiff chooses to try to domesticate the judgment by enforcing it somewhere else, then attack the judgment at that point. You may recall that's what happened in McGee versus American Life case, right? There was I believe, a default judgment in California, and then when a plaintiff wanted to domesticate it in Texas, at that point there was an attack on PJ. All right. Or how about the Penoria versus Neff case, right? You had a default judgment in Oregon. And of course, there apparently the defendant didn't know about the default judgment, and then later on there was a collateral attack on that default judgment, right? So sometimes people default accidentally, sometimes people default on purpose. All right. Keep in mind, under default, there's a difference between entry of default under Rule 55A and default judgment under 55B. Entry of default is almost ministerial. What the plaintiff can do is by affidavit. What the plaintiff can do is let the clerk know that the defendant has not appeared or otherwise defended, and then the clerk must enter the default. All right. But entry of default under 55A does not entitle the plaintiff to relief. Instead, what the plaintiff's got to do is get a default judgment under 55B, and that's a lot more involved. That might involve the need for a hearing and all of that. And from there, I'm going to refer you to the rule. One thing I'll add about a default judgment, it's not just defendants that can default, right? You can have a plaintiff who defaults. So if you have P versus D, what if D sues P and P never responds to the counterclaim that includes the answer? Okay. So there you go. Now, pre-answer motion is exactly that. It's a motion done before the answer. And we talked briefly in class about a 12E motion for a more particular statement, right? Standard for that is when the pleading seeking relief is, when a pleading is so ambiguous that the responding party cannot reasonably form a response. Okay. The hypo I believe I used in class was that P sues D, and P says, "You armed me, and therefore are liable to me for $1 gazillion." Okay. You also have the motion to strike under Rule 12F. Now, motion to strike is used to strike scandalous, immaterial, impertinent manner. You sue somebody for negligence, and then you start attacking their morals and scruples in a way that is completely unrelated to the claim. That would be a basis for a motion to strike. One example of a motion to strike that students often forget, however, is a motion to strike is the legal vehicle that a plaintiff can use to get insufficient defense struck from an answer. Okay, so here we have P sues D for negligence, and D answers, and D says P is, let's see, ugly. So say you have a citizen sues a police officer, okay, not for negligence, let's make it battery, and then police officer responds saying, "Plaintiff is ugly, and I am police officer, can beat people up because I want to, all right? Well, this here will be something that might be struck under the regular parts of Rule 12F, right? As being immaterial, scandalous, whatever, perhaps. But this part seems to be some sort of affirmative defense, right? I'm a cop, and that gives me the right to beat up anyone I want at any time for any reason. Well, that's a ridiculous defense, right? There's no such defense under the law. So guess what? Plaintiff, the citizen, ought to move under Rule 12F to strike this defense as being a legally insufficient defense. In other words, a Rule 12F attack on a defense is kind of like doing a 12b6 attack on a claim, right? All right. So we talked about 12b, we talked about 12f. Now let's talk about one of the biggies, which is Rule Gesundheit 12b. All right. And there are 7 defenses listed in Rule 12b, right? 7 defenses listed there, and we've got those old waiver provisions. Now these 7 defenses can be raised by pre-answer motion. They can be raised by answer. Some of them can be raised post-answer, right, via other means such as amendments and motions and the like. So let's think about the motions themselves. All right, you got the favored, you got the most favored, and you got the disfavored, right? The favored is what, the 12b6 and the 12b7, all right? So 12b6, motion to dismiss for failure to state a claim. 12b7, failure to join a party required under Rule 19. Now that we understand Rule 19, right, from other parts of the study, we know that Rule 19 is oftentimes used by defendants as a way of trying to get dismissal. You say there's somebody who's necessary, who should have been joined, but they can't be joined because joinder is not feasible. So therefore, let's dismiss the whole case under Rule 19b. So Rule 12b7 is a way of using Rule 19 to get the entire civil action dismissed. Well, these can be raised through trial, right? These can be raised through trial. And the reason, one reason is 12b6, if in fact the plaintiff's claim doesn't state a claim for relief, all right, why in the world should the court be wasting its time having a trial, right? So that defense could be raised really late. Similarly, with Rule 12b7, if in fact there is somebody who's so important, a VIP to the case, that they ought to be joined, but they just can't, for example, joinder of that absent person might destroy a diversity jurisdiction, then maybe it's not fair to that absent person for the case to continue. Maybe the case should be, the entire civil action should be dismissed, and then the case can be refiled in a state court of more general jurisdiction. Okay? So again, that can be raised later. Most favored is our 12b1 attack on subject matter jurisdiction. All right, that can be raised all the way through appeal, right? In fact, if the case is decided, goes to the Court of Appeals, the Supreme Court, it's remanded down to the Court of Appeals, goes to the trial court, goes up to the Court of Appeals, goes down to the District Court, goes up to the Court of Appeals, goes back up to the Supreme Court. And then only then does Justice Scalia say, hey, I think there might be a problem here with subject matter jurisdiction. Boom! The case is gone. It's out of there. Millions and millions of dollars of lawyer fees wasted because nobody bothered to read the diversity statute, right? So don't let that happen to you at home, guys. All right? So that is the most favored defense. Of course, the disfavored defenses, not disfavored, but disfavored, will be the defenses 12b2 through 5, like a PJ, like a venue, improper process, and improper service of process, right? Now, those are, with an exception, with a biggie exception, those are waived if they are not raised in the initial response. Thus, here we have the initial IR response rule, R. So the R initial response rule, all right? Now, again, why is that? Why is that? If the favor can be raised through trial, most favored, even on appeal, okay? And why? Because that goes to the core of the court's power, right? So it's an issue about the court's power. Disfavored is very easily lost. Well, first, these are personal defenses, okay? They go to the rights of the defendant. So if the defendant doesn't care enough to raise them, why should the court care, right? You know, PJ is what? About the unfairness of dragging somebody into a distant place. Venue is about what's the best pace for trial within the court system, right? Process and service of process is about the papers and about the manner of service of the papers, all right? Defendant doesn't care, why should the court care? But also, the basis for an objection to these is usually easily seen just by looking at the face of the complaint, right? Because the complaint under Rule 10 has to have a caption that lists the parties, right? Rule 8A1 says that short, plain statement for jurisdiction is required, right? So all that stuff that's relevant to these is either going to be on the face of the complaint, or the defendant ought to know by the manner of service of the complaint and the summons, or by looking at the summons itself to see if there's some sort of problem with the process itself. All right? So these are examples of use them or lose them. Let's talk a little bit more about the nature of the use it or lose it rule, right? So like I said, it's got to be your initial response in which you put one of those disfavored defenses or you lose it. Well, that depends on what your initial response is, right? If your first response is a pre-answer motion and you move to dismiss for lack of PJ and it's denied, boom, court denies it, then you serve your answer and you assert venue, well, it's too late, right? You can't do that, all right? Well, say in your answer you assert venue and lack of SMJ, all right? Well, the venue was waived, right? But SMJ, that's okay, because that can be raised way, way later on. So that's all right. Now, how about answers, right? Here's an answer. All right, you assert PJ. And then you have an amended answer in which you assert venue. All right?
Wait.
Well,
Okay.
it's gonna depend. It's gonna depend, right? What if I tell you this amended answer was done a year after the initial answer and done by leave of court? Is venue good or not?
No.
It's not. What if I tell you instead the amended answer was served 10 days after the initial answer and done as a matter of course by the plaintiff merely doing a redo?
Yes.
The
Yes.
answer is yes, you see? So remember how I said that all that matters is your initial response, right? Subject to an exception? Here's the exception. And the exception is this. If your initial response is an answer, and you amend that answer under Rule 15A, what's it, 15A1, I believe, as a matter of course. So for here, for example, the defendant would have 21 days. There's some other twists on 15A1, which you can look through. Let's keep it basic right now. As long as this amendment is within 21 days of the service of the original answer, then this venue defense is still okay. And to look this up, and this trips up a lot of students, you'll want to look at the relevant rules, which is 12H1 and Rule 15A. Okay? I believe it's 12H1A2. All right? You can look at the numbers yourself. And then 15A1. All right? I believe those are the exact rule sections. Which, oh, by the way, reminds me of something. You remember, if you want to cite case names, great, yay. If you want to cite our rule numbers, great, yay. You want to give me sections numbers, yay. But you also got to give me the law, right? You know, the section number or the rule number is never a sufficient proxy for what the law actually is. You want to have a rule statement, right? All right. So this would be okay. All right. Moving right along then. Last thing to say about the initial response rule is you'll note that under Rule 12G, I believe, 12G, that this waiver rule we were talking about applies to defenses that were available to the defendant at the time they served their response, right? Now, it's going to be pretty rare that an objection to PJ, venue, process, or service of process isn't available to the defendant at the time they serve their response. But go back to the notes, and I gave you some examples of where it might be different. Glennon has some examples of that as well. All right, continuing with our discussion, keep in mind that with an answer, there's some additional twists, and it almost starts to bring up some of the jointer issues that we'll talk about in a little bit. All right. An answer can contain a number of things, right? Admits or denials. It can contain affirmative defenses, or I should say defenses. And it can contain counterclaims or cross-claims, right? These are all things that go in an answer, or more accurately can go in an answer. Now, regarding admitting or denying, now we're talking about, in particular, Rule 8A as well as Rule 8D, as well as other parts of 8, but particularly Rule 8A and 8D. If something is true, you got to admit it, right? And if something's untrue, you got to deny it, okay? But you got to be careful about how you admit or deny, because you should admit to the things that are true, deny the things that are not true. But sometimes allegations and pleadings are very tortuously written. And some parts might be true, and some parts might not be true. So, if somebody alleges against me that, on the day of the Civ Pro review, Professor Nathanson wore beige pants, a red polka-dotted bow tie, and a red shirt, okay? Well, I might be tempted in my answer to say, denied. The allegations of paragraph whatever are denied. But keep in mind that Rule 8b also points out that you have to fairly respond to the substance of the allegation, okay? So part of it's true and part of it's not. Then what I might say instead is, defendant admits that he, on that day, was wearing beige pants and a red polka-dotted tie. He denies the remaining allegations of that paragraph, right? So you have to be careful about how you deny and how you admit. And also be careful that the way you deny and admit is not overbroad. Don't admit to more than you intend to admit to. So, for example, I probably would be reticent to say, Professor Nathanson denies that he was wearing a red shirt. The remaining allegations are admitted. Okay. What if there's something in there I forgot to respond to? Maybe what if the complaint said, Professor Nathanson was really mean that day while wearing the red polka-dotted tie, the beige pants, and the red shirt. And then I say, Nathanson denies wearing a red shirt. The remaining allegations are admitted. I just admitted to being mean. I don't want to be mean, right? I certainly don't want to admit to it, right? So you got to be careful. Let's see what else. What happens if Nathanson responds to the second one about him being mean and wearing the red shirt? Nathanson just says Nathanson admits to wearing beige pants, okay? And I say nothing else. Then I've admitted everything else, right? Because if you have an obligation to admit or deny, and you don't respond to the allegation, then you've admitted the things you haven't addressed, right? With the exception of damages, right? The amount of damages, you don't have to admit or deny those. All right, look at the list. All right, next, affirmative defenses. Well, or rather defenses. Well, first we got your 12B defenses, right? In your answer, you can put your 12B defenses, the ones that are still you're able to assert, as well as Rule 8C affirmative defenses. All right. Now, 8C affirmative defenses, recall the listing in Rule 8C is prefaced by the word including. So you got this laundry list, right? And that laundry list includes lots of things that you know to be affirmative defenses, but aren't listed there. So, for example, I believe contributory negligence is listed there, but comparative negligence is not. But you all know that comparative negligence is an affirmative defense, right? Okay, so the listing in 8C is illustrative listing. It is not an exhaustive listing because of the use of the word including. In comparison, if you would look at Rule 8, look at the Rule 12b, the list of defenses that can be raised by pre-answer motion or in the answer. That says, what it says is the following defenses. The following defenses may be asserted in this manner. Okay? What that means is the listing of 1 through 7, B1 through 7, is exhaustive. That's it. All right? That's it. All right? So in your answer, you can assert 12B defenses as well as 8C defenses. A side thing worth noting is that 12B defenses, the waiver of those are handled through the waiver provisions of Rule 12, namely Rules 12G and Rule 12H. However, an affirmative defense, like an 8C defense, is covered not through Rule 12. Okay? That's not through case law. And go back and look in your Glannon, and he has some materials talking about that. An affirmative defense, like comparative or contributory negligence, whether or not that's waived is going to look to other circumstances. For example, has the defendant unduly delayed asserting the defense, right? Would allowing the late assertion of the defense unfairly prejudice a plaintiff, and so on. So it's going to depend on additional facts that is going to be determined by case law. You can waive a Rule 8C affirmative defense, but that waiver is not governed through the waiver provisions of Rule 12. Okay? Now, for further guidance on this, if you're interested and want to do a nice hypo on that fact pattern, you can look at my last spring's exam. I believe question 1 has a nice little Rule 12 and 8, waiver questions. Like, defendant has a whole bunch of amended answers with a bunch of various defenses. Then the follow-up question is, which defenses were waived? Which of the defenses asserted were waived? Okay. Another side thing is always read. You know how I say read the fact pattern multiple times? I'll double that for the call to question. Read that call to question so carefully, okay? So that you don't go off on a tangent and either discuss the wrong issues or discuss additional issues that weren't called for by the question. And it's a very common mistake of all law students, but it's one that kind of sucks up your time, right? And there's nothing more heartbreaking to me as a professor than looking at an exam that's cogently written, thoughtful, and discusses all the wrong issues. It breaks my heart. It really does, right? Because somebody made a mistake. So no, please don't let that person be you. Let's see. All right, well, counterclaims and cross-claims we'll get to when we discuss joinder. So let's move on. Let's see, what should we talk about next? All right, well, let's talk about Rule 15. Rule 15. Because it's 3 more than 12. And Rule 15a, of course, we talked about at some length, right? Amendments. You have amendment as a matter of course. We talked about that some. If it's too late to do an amendment as a matter of course, or you've already done your one amendment as a matter of course, right? You only get one. You only get one amendment as a matter of course. If you can't do any more amendments as a matter of course, or it's too late to do one, then you can seek amendment by getting consent of the other side, right? Or you can seek leave of court. In other words, make a motion. And the kind of presumption there is the court is inclined towards granting leave to amend, right? Because the rule says leave to amend will be given freely when justice requires it, right? So unless there's a showing that the defendant, or not the defendant, that the moving party, rather, unless there's a showing the moving party has engaged in undue delay, right? Or that the opposite side, opposing side, would be unduly prejudiced, right? Or that the amendment would be futile, right? Then the court is inclined to grant the leave to amend, right? In fact, normally, if you have a dismissal, here's another nice little kickball point for you. If you have a dismissal under Rule 12b-6, normally the court is going to either give you leave to amend or dismiss without prejudice, right? In other words, to give you that do-over. Why? Because maybe the defect in your pleading is not one of legal insufficiency, but rather a factual insufficiency. And maybe you just need to do a little bit more investigation and beef up your factual allegations to fill those holes, right? So normally the court's going to give you a second shot, unless amendment would be futile, right? So we go back to my very first day hyper, right? I mean, we talked so many times about there's a birthday party. Nathanson's not invited. He's very sad. And he sues somebody for willful failure to invite, right? And the court grants the defendant's motion to dismiss. Like, what is this, right? And plaintiff says, wait, I want leave to amend. I want to amend to make it willful failure to invite, right? And, you know, here I would hope that the court would deny leave to amend because amendment would be futile. You know, here we have a problem not of what factual insufficiency, we have a problem of legal insufficiency, right? Not only is there no cause of action that I've ever heard of failure to invite, there's certainly not one called willful failure to invite. What if I make it really willful failure to invite? No, that's not going to go. So, 15A. We talked about 15B and D in class. You can look back to your notes for that. But right now I thought you might want to hear a little bit of talk about 15C, relation back. Unless you don't want to hear that.
Yes, it is.
You do? You're certain?
Yes.
Okay, I guess we'll talk about that then. All right. Now, you know, make sure you have your statute books open, you know, to the relevant rules. Now, note first that Rule 15C has three bases for relation back. Cam's recording okay, right? Yay! It's working well. You know, what I'm gonna do, as long as it's able to upload okay, is I'll upload this to YouTube, okay, and I'll send you an email, because the only thing more fun than sitting here today and having a 3 or 4 hour review is sitting at home and watching it again, right? And I'm currently in negotiations with Netflix to see if we can get this. You know, like bow ties are the new black, right? Instead of orange is the new black. All right. Really, I don't write this stuff in advance. It just happens. Relation back. All right, 15C1A. An amendment to a pleading relates back to the date of the original pleading when A, the law that provides the applicable statute of limitations allow a relation back. I have never tested on 15C1A. I've never tested on that. Never, ever tested on that. Not to say that someday I won't. However, the circumstances under which 15C1A apply would be when the relevant statute of limitation, okay, or the cause of action, or some relevant law, like a statute, says, if we're going to have relation back, this is how it works. In other words, 15C1A refers to some other law, like a state statute that says, relation back in this circumstance will only be permitted if X, Y, and Z conditions happen. Different conditions than might be in 15C1B and 15C1C, all right? I don't, if I test on it, and please don't think that I will or will not. Okay, you know my standard spiel with review sessions. The mere fact that I say something during this review does not indicate that it will be on the exam, nor does the omission of something from this review mean that it will not. This program is owned by the NFL, and you can't copy it and play it. All right. All right, disclaimer. So, you know, sometimes I'll see people, when I do test on it, go through the whole C1A, C1B, C1C, and like just hit all the bases. But you should only talk about the base or bases that apply, right? And if it's just a regular old, say, like a negligence or a conversion or a breach of contract or copyright or whatever thing it is, all right? In other words, if I don't give you some statute that indicates specialized state or federal rules in relation back, then C1A doesn't apply at all. And for further guidance on this, go into Glanted, and he gives an example in the case book on when C1A would be applicable. All right? So unless you see some sort of specialized rule or statute, C1A is not applicable. Now C1B kicks in when a claim or defense is being amended, okay? But when there's no change of the parties, okay? C1B on its face, C1B by itself is when the parties are the same, but say we're changing a claim, or changing a defense, or adding a claim, or adding a defense, okay? And we're asking whether or not that added or changed claim or defense arises from the same conduct, transaction, or occurrence that was set out or attempted to be set out in the previous pleading. To make sure I don't keep walking off of camera. That would be annoying to watch. I'm good. All right. All right. Now, C1C, in contrast, kicks in when we are, now look at the language, right? Bless you, Greg. Changing a party or changing the name of a party, right? Or by Krupski, I believe it's footnote 3, referring to also adding a party, right? When we're bringing in someone new or we're changing the name of someone, okay, we're changing a party, that's when 15C1C kicks in, you know, when we also have a statute of limitations problem, right? And there's a whole bunch of elements here. Now, here's something that I shared with a lot of you when we talked to my office. Like, the students will say to me, Professor, how should I write the rule statement? And I generally say, well, that's your job as a student, right? Is to figure out how to state the law. And that's just not being Socratic or mean or like, you know, lazy or saying, yeah, when I was young, I had to figure it out for myself. The better, if you can state the law in a clear way, even in your own words, okay, then you're much more likely to understand each part and how they all fit together, okay? And if you understand that stuff, then most likely your essay is going to be better organized, and you'll spot more issues, talk about more nifty stuff, and I'll smile and give you more points, okay? So one of the keys to doing a good job on an essay is being able to explain to me in your own way what the law is, right? And not to just memorize some language, because memorizing isn't understanding or applying, right? Not just to like copy Rule 15. So I test your relation back and you just type in whatever 15C1C says, right? Got it. Got those points. I'm good. You know, because I see a lot of people do that. They'll type in the language of 15C1C. Then their essay shows they really don't quite understand what each part is and how they all fit together, right? And it's really important to be able to do that. So I'd almost rather see someone who a little bit inelegantly states the law, but states it in a way that shows that they really understand it, okay? Now, how do these parts fit together? Well, first you got first you got to have a problem with the statute of limitations, right? So here's the statute of limitations. The complaint is filed. Time flows. And later on we have an amended complaint, right? And the amended complaint is going to be sometime after the expiration of statute of limitations. So say the amended complaint is right here, all right? And the question is going to be, do we turn back time? That's a Cher song, right? We turn back time. Yeah?
Yes.
Yeah, it is. Okay. You know, if you take the boat cruise in Fort Lauderdale, the water taxi, they take you right past, have I already told you this? Right past the house where Chaz Bono was born? Yeah, it's a little white house in Fort Lauderdale. Yeah, cool. All right. Can we turn back time and treat this amended complaint as if it were filed the earlier date when the timely complaint was filed? Well, first, the rule says, you know, 15C1C is when you have changing the party or the naming of a party, right? But what about adding a party? You know? So say you have P versus D, and then later on, you have P versus D with the complaint. Later on, you want to amend the complaint to add a count against D2. We're going to join an additional party. Well, the language on its face doesn't seem to support that, right? We're not changing a party. We're adding a party. You know, in expressio unius, if the rule makers had intended 15C1C to apply to adding a party, they could have said that. But Justice Sotomayor in Krupski says, kind of ipsy-dixit, kind of like, well, make it so number one, right? That adding also counts. All right, so adding appears to be okay. But then there's other parts as well. You know, the rule says relation back is okay if additionally rule 15C1B is satisfied. What that means is 15C1C incorporates 15C1B by reference. That means C1B is an element of 15C1C. In other words, you have a situation where you're changing a party, changing the naming of a party, or adding a party. Your relevant rule is not C1B. It is instead 15C1C. And 15C1B is an element, the second element of C1C. So you got to do C1B, right? In other words, conduct, transaction, or occurrence. Is the CT or O of the amended complaint, did it arise out of the same CT or O of the original complaint? All right. Now here, you know, I'm seeing some very cursory analysis in the student essays that are coming to see me, and I've talked to a number of you guys about it. You can look at a number of things. Think of, for example, Peter Parker suing Paul Pierce and ABC, and later on wants to join XYZ, right? All right. Well, you know, you can look at a whole bunch of things, like the injury, right? The injury is common to all three causes of action, right? We can look at the legal theory, right? You know, you got negligence being asserted against ABC and XYZ, but you got battery being asserted against Paul Pierce, right? See how the legal theories differ? Well then, you know, you get some opportunities for analysis and counter-analysis here. Something like this is a nice meaty issue where you can rack up some points. It's like pinball, ding, 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 ding. You want to get those, right? What else? You also have the acts, right? The acts or omissions. Well, heck, you know, ABC was sued for its design of game as well as the manufacturer. Paul Pierce was sued for the battery, which is when he threw the controller at Peter Parker, right? And then you have XYZ is being sued for its design, but not of the whole game, but rather of the graphics. Now these are all acts that happen in different places at different times, right? So is it the same CT or O? I don't know. I don't care. Argue it, counter-argue it. Use those legal noggins that you've developed here, right? Being a good lawyer is about empathy. It's about being able to get into the heads of other people to look at things from their perspective, or to look at things from others' perspective. We do this when we think in our head about, what if this happens? What if that happens? What will happen then, right? It's our imagination, right? Like SpongeBob. Use your imagination, right? So when you get a nice meaty issue like this, you should be thinking about, how can I argue it in multiple ways? And that makes you not only better on your exam, but it makes you a better lawyer. Because the smart lawyer is the one that's able to get into the head of her or his opponent, okay? Even before you serve or file something, even before you send a letter, even before you make that phone call. Imagine what they're going to say in response to your argument, right? And then think, well, maybe I need to improve my argument, right? Or we'll have a counter to their counter, right? I mean, you do this in your life all the time. That's why we're social beings, right? Because we anticipate how other people are feeling by their body language or their facial expression, right? This is really relevant to the law. And I submit it's really relevant to your exams as well. You always want to think of things from different perspectives. Okay, moving on. So the second element, conduct, transaction, or occurrence. Think of all the good things you could say. But there are other elements as well. And the next one is the timing, all right? There's that 4M period. That 4M says that the complaint and summons must be served on the defendant within 120 days of the filing of the complaint, right? And therefore, what I have a lot of people saying to me is, well, imagine this fact pattern. Here's the complaint, here's the statute of limitations, here's 120 days. Got it? And the amended complaint is way off in the distance here, way more than 120 days. I have a lot of people saying to me that, oh, well, the 4M period has already passed. The defendant to be brought in wasn't served within 120 days, and therefore relation back is not proper. But that's not how the rule works. Here, the structure of the rule tells us what the timing here is for. The rule says, quote, within the period provided by 4M for serving the summons and complaint, the party to be brought in by amendment, 1, receive such notice, blah, 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 not be prejudiced in defending on the merits. Semicolon. And 2, knew or should have known that the action would have been brought against it but for a mistake concerning the proper party's identity. Structurally, what that means is the 4M period of 120 days from the filing of the complaint refers to 2 sub-things. Notice. Second, knowledge. Now here's my fact pattern. The amended complaint is more than 120 days after the filing of the original complaint. Well, let's suppose notice and knowledge were received within the 120-day period. Is our timing okay? Yes. Yes, it is. Yes, it is. Now, regarding the notice, it's not just notice. In the ABC XYZ hypo, there was that Sun Sentinel article that was posted to Facebook, right? And everybody said, well, that gave notice. And as Krupski tells us, notice need not be formal. Okay, so maybe a news article could suffice. But then people said, oh, there was notice. It was within 120 days, and we're good. Well, the problem is it's not enough to get notice. It's got to be the kind of notice that prevents prejudice in defending on the merits. In other words, did the defendant get notice with sufficient time that it was able to start preparing a defense? Were files destroyed by then? Had people died? You know, were materials they need gone? Will they now be able to put together a defense, or is it just too late? Okay. Now, I think in the ABC fact pattern, there wasn't any prejudice because the timing was really quick, right? But that's an issue you need to address. Knowledge. The knowledge has to be within the 120 days. You ought to point out to me that the knowledge ought to be within 120 days. Okay? But additionally, it's knowledge regarding the mistake. And Krupski has all sorts of wonderful language talking about mistake, right? Use dictionary definition, makes that wonderful distinction between knowledge of the existence of a party versus knowledge of the role that party played, right? So the ABC XYZ fact pattern was really on all fours with Krupski, right? Because the box of the video game listed XYZ as somebody who was involved in the game, but it didn't say what they did for the game, right? And it was only through the article did the plaintiff's lawyers learn that XYZ designed the immersive graphics that hypnotized Paul Pierce and caused him to throw the controller at Peter Parker, right? And that's why the amended complaint, there was a motion for an amended complaint. All right, well, this is an example where the plaintiff knew or should have known of the existence of XYZ, but there was nothing in the facts to suggest that the plaintiff knew of the role that XYZ played in designing the immersive graphics, which were a key part of the claim, okay? A key part of this case. What if the box had said, we want to thank XYZ for designing these incredible immersive graphics that make people feel like they're actually, battling in a war, right? That was on the box. And say then the plaintiff makes the deliberate choice to sue only ABC and Paul Pierce and not to put in XYZ, right? Then we have kind of deliberate choice with knowledge of not just the existence of XYZ, but also its role, that wouldn't be a mistake. Krupski tells us that as well. So think about what qualifies as a mistake. All right, so I guess that's Rule 15. Let's see, what time is it now? 12:15. Why don't we reconvene at 12:20? All right, only take a little break. Let everybody rest their minds and go to the bathroom or get a drink of water or get some coffee. But once it's 12:20 on this clock, I'm starting with or without you. Okay, so everybody please try to be back so that we don't get interrupted.
Thank you.